problems, especially in the legislative sphere. I would like to introduce the members of the discussion. So Mr. Kari LAMBERG, the lead advisor on the work of prosecution bodies. He represents the EUAM report in his presentation. So we expect that he's going to share the experience of the EU countries in this sphere, the experience of Finland, as Kari is a citizen of Finland, and I think that the experience that he's going to present is going to be very interesting and very relevant for the topic of our panel discussion. Then we'll be listening to Mustafa NAYEM. He's been a little bit late and he apologized for that. So he's the MP, and it would be very interesting to get his view regarding the legislative actions with regards to the solution of this issue. Then Mykola KHAVRONIUK, the professor, member of the political and legal reforms. So Mr. KHAVRONIUK is my friend and my colleague, and apart from that, he is the author of the draft law on misdemeanors, which has been discussed for a long time in various institutions in the Council of Europe. It was also discussed with the international experts. It was presented to the Verkhovna Rada and caused significant discussions. Due to some circumstances, including political circumstances, unfortunately, consideration of this draft law was blocked. Then we will listen to Mr. MONASTYRSKII. So, Mr. MONASTYRSKII is a representative expert at the Ukrainian Institute for the Future, and we will be interested to get his views on the solution of this problem. So from the analytical point of view, from the expert point of view, and also it will be good to get his views as the third sector representative. Then I would like to give the floor to Dmytro CHIBISOV, Chief Prosecutor of Kyiv Regional Public Prosecutor's Office. And of course, we are not able to consider such an issue without the involvement of practitioners, and the prosecutor is the lead figure in the prosecution. So, and therefore, it will be very interesting to get the ideas and views from the prosecution bodies. So this is our list of speakers. So, and therefore I would like to give the floor to Mr. Kari LAMBERG, and I would like to ask the speakers to follow the time frame of 5 to 6 minutes, and after the presentations we would be ready to start a short discussion. So through the exchange of opinions with the engagement of the wider audience present here. So I would like to ask all of you to take part in the discussion on this issue.
Good afternoon, ladies and gentlemen. My name is Kari LAMBERG. I'm a Finnish prosecutor. I have been working in Finland within university, in the judiciary, as a military prosecutor, and as a deputy police chief for 9 years. And since 1996, I have been as a prosecutor because we changed our organization. Before, part of the prosecutors were serving in the police forces, doing at the same time investigations and prosecution. And I have been several years in countries like in Bosnia, in Kosovo, Palestine, Afghanistan, working as a rule of law advisor and prosecution expert. About the issue today, we have heard reasons for the workload of investigators. I'm not repeating them, but do these reasons European countries have established special procedures for minor crimes. How to make a simple, but anyway, legal system to solve all these minor crimes. With the minor crimes, I'm referring to Criminal Code Article 12, where you have a definition of minor crimes. And during our work here, we have heard that this workload is such that it is slowing down investigations and also having impact on qualification, quality of the investigations. And the main reason is that legislation is not, good legislation is not in place. That's why we would like to have in Ukraine some changes in the legislation which will lead to a situation where minor crimes can be processed according to Chapter 25 of Criminal Procedure Code. This can be done, in my opinion, in two ways. Either what I prefer first, to make changes in the Criminal Procedure Code. Change Criminal Procedure Code in a way that it's in the same line with the Criminal Code, had the same definitions, and then change this Criminal Procedure Code so that this Chapter 25 can be applied. I have heard that this law on misdemeanors is also proposed. I don't prefer that because it means that you will have a new law again, more laws. It's more simple that you have only a few laws which are covering the whole area. But the solution and decision will be made by Ukrainians. You will choose what is the best for you. When making these changes, I also advise to have a look on the procedure itself, also the court procedure. I would like to mention, for example, article number 302 of Criminal Procedure Code, where it's mentioned that when you want to use this simplified procedure, you have to have a document from the suspect that he is giving his permission and he is admitting the crime in the presence of defense counsel. Is that possible all the time? Do you have defense counsels all the time available, and who is paying the costs? In Finland, this document is made in front of police, which is, in my opinion, very natural place to give this permission. Why you should use this simplified procedure for minor crimes? This minor crime, it's an offense of low social danger. They are not so serious crimes. Often they are also very clear to investigate. And if you think about legal protection of citizens, you can also bear in mind that always you can use this regular investigation and criminal procedure. So shortly, these changes will reduce workload of investigators. They will save costs and also speed up the process. And that means also, if you have a good, effective process, that trust on authorities will also increase. A few words about Finnish system. In Finland, all police officers can make investigative actions, obtain evidence which can be used in the court, every police officer. And in Finland, about more than 83% of all the criminal cases are solved in a simplified procedure. Difference is that we have only criminal offenses. We don't have these administrative offenses as you have here. But anyway, we have a very big amount of cases, which most of the cases will be solved in a simplified procedure. And after that, we have step-by-step procedures, so that only 6% of all cases will go to the court main hearing. All the others have been solved either by police or prosecution or in simplified procedure in the court, a written procedure. And in Finland, compared to these figures we saw from Germany, Finland has the lowest number of police officers compared to the population. So we have around 730 inhabitants for each police officer. Due to time, I thank you for this, and let's discuss later on. Thank you.
Дякую, Карі. Ну, по-моєму, дуже корисний вступ до нашої дискусії.
Was a very useful introduction for our discussion, that the introduction of a simplified procedure would help save resources and time and would positively impact the citizens because they would feel more safe. And Kari told about Finland, where more than 83% of cases are processed under simplified procedure. That means that a huge number of crimes are considered under simplified procedure, and that helps save time and resources. And this means that the goals of the criminal investigation are achieved. Now I would like to give the floor to Mr. KHAVRONIUK, who will tell about Ukrainian realities. Will tell us more about how legislative changes can help regulate this problem, the heavy workload of investigators. Thank you.
Thank you very much. Dear colleagues, thanks very much for being ready to listen to my presentation, and I would like to ask somebody to switch on the presentation, the slides. Meanwhile, I would like to say a couple of words regarding the draft law on the criminal misdemeanors. Mr. Moderator has touched upon that. So the draft law was not adopted mainly due to the organizational reasons. So any draft law which is being presented for the consideration on Friday afternoon is very likely not to get the required number of votes. And in this case, we saw that 212 or 213 people voted in favor of this law, meaning that only a small number of votes was missing. So within the draft law itself, there is nothing which would object its adoption in the first reading. So we will continue working on this law, and I'm not a person who is going to stop if we have got a first obstacle. So we'll be finding and we'll be looking for other ways how to get it adopted. So the main topic of the discussion is a reduction of the workload on the investigators and operatives. So I remember about your request. I'm going to use this slide for just a second. So in order to refer the audience to the bodies of the pretrial investigation, the law on criminal misdemeanors allows to investigate the crimes by other pretrial investigative bodies. What investigators' bodies are meant, so it's not clear, and for me it is also not clear. Anyway, if we think that all these other bodies are the workers of the operative and search units, so then we are wrong, we are mistaken, because the legislator couldn't have made such a mistake that a highly qualified specialist who have been trained for a long time, trained within the Ministry of Internal Affairs system, so who were focused on detecting the gravest crimes. So it's not possible that they would be delegated to investigate the criminal misdemeanors. So it's essentially comparing when we use a microscope to crack the nuts. So any institutional system, including the system of the pretrial investigation, should be based on certain principles. So the key two principles are the principles of rational distribution of authorities and responsibility. So rational delineation of authorities means specialization of the investigators and the operatives. So specialization means assigning certain areas, certain criminal areas, to particular bodies and persons. I think I would object to the approach which has been presented today by the head of the NPU and his deputy head on the main investigation department. So the approach which is based on the type of gravity of a crime. As an investigative judge with 10 years of experience, I had a chance to investigate different types of cases. So, and I was in charge of the administrative cases. I was in charge of the cases and proceedings related to rapes, traffic accidents, etc. So, and for me it was very difficult, and therefore I would support specialization and categorization. It doesn't mean that a person for the rest of his life will be investigated only a particular type of cases and crimes. It means that it's only possible to work in one sphere and develop yourself and then change the topic of specialization as this person wishes. With regards to the responsibility, it means responsibility for the status of the investigation of crimes in the country in general. And as we have seen today, using the FRN, so the responsibility lies with the Minister of Internal Affairs and the head of the National Police. So in our case, this responsibility is dispersed between different bodies. We have now, using the experience of the US, which is a very powerful state, and we decided that we can create many investigative bodies. We are not able to do that, and I can explain why. So, according to the statistic data of the GPO, so 95% of all cases sent to the courts, these investigations were carried out by the national police, prosecution bodies, which fulfill these functions, and this is not unconstitutionally. So the prosecution bodies account for 4.4%. So other bodies account for 0.1%, 1%. So it's not worth even mentioning them. In the system of the investigative bodies of the NPU, I would like, order to improve the work, I would suggest to have the following breakdown between different units and sectors. So they will be focused on particular types of crimes, but not their gravity will be the classifying factors. So crimes against the person, crimes against the state, and crimes of a general type. As for the special investigative units, at the level of regional departments of the NPU, it's worth establishing powerful, strengthened, enforced units, and the system which is established in FRN. So it demonstrates that the federal police is in charge of investigating organized crime cases. So the lower police units, so who are working on a lower level, they are working on less dangerous crimes. So with regards to the investigation of the criminal proceedings, criminal crimes, so it's important to have the evidence of evidence. So it's not possible to have covered investigative activities. So minimum restriction of human rights. So that all refers to the investigation of criminal misdemeanors. So, and in general, we need to have a simple methodology of investigation. So, and therefore, according to my data, investigation of 120,000 cases can be done by people who are investigating the criminal cases, so operative workers. So they have got certain memory. 5 years ago, they were called the inquiry bodies, and they were actually dealing with the investigation of crimes, so in the inquiry form, and they and their colleagues in certain agencies, so they were administrative bodies, and in this list you can see the bodies of internal affairs who bear the biggest burden. So, and some other bodies, they were able to combine and unite all that, and based on that, I would like to draw your attention to the positive foreign experience, specifically French experience, where the same representatives of police bodies and some other agencies, they investigate so-called misdemeanors and so-called police violations. So they categorize these offenses, so they decide whether they refer to administrative or criminal offenses. They decide what procedure should be used for their investigation. So they fill in the protocols, and if the perpetrator agrees, this protocol means a completion of the investigation. And if they see certain signs, certain characteristics of a criminal case, under the guidance of the prosecutor, who is guiding them in the legal area, they send the proceeding to court. And this system can ensure not only due implementation of human rights in Ukraine, but it can also reduce the burden of investigators and provide the investigators with an opportunity to focus the activity of the investigators on the most important and serious crimes. Thank you very much. Thank you very much for a very detailed presentation. So thank you very much for a very interesting points, and I would like to give the floor to Denis MONASTYRSKII. So thank you. Good afternoon. I would like to start with some general issues. So when we talk about the workload on the investigators, and we have mentioned that today, so it's impossible to discuss this issue separately from the workload on the prosecutors and the court system. And today, when we discuss this issue from the one side, when we accuse the judges that the investigative judges are not providing necessary support in the pre-trial investigation processes. So today we have heard the facts that the staffing of the court is also under significant pressure, and this problem should also be solved. So one of the options for the solution of this problem, and this can be done over 1 year, which would lead to the reduction of the workload, this is essentially introduction of the electronic criminal proceeding system. And each structure, and I mean the prosecution bodies and PU, the court, so this can be used in all 3 of them. But each member of this system is pulling in different directions, and from my point of view, it's a very big problem. So a system which is developed separately won't be able to counteract and work in partnership with other systems. So, and what is being proposed with regards to the implementation of this system is not going to be effective because it won't be possible at the technical level. So, and here is a discussion between the prosecution bodies and the court, what should be the basis for this system. Also, there is a question when we talk about the investigation of crimes, so and minimum cost of the property which would entail responsibility. As far as I know, several years ago, there was an attempt made to evaluate the cost of the work of an investigator in order to assess what are the costs of the state for the investigation of a particular type of a crime. So, and it turned out that essentially the cost of the investigator's work was much more expensive than the cost of the property. So, and these discussions are very relevant right now, because when we're talking about reduction of the workload, we also need to take this into the account. Regarding the norms of the workload, and that was discussed during the Soviet times and during the independence, there are certain workload norms. So what's the acceptable number of cases, proceedings for the investigator? So from 30 to 50 proceedings is considered to be a normal number, dependent upon the gravity. So do we need such norms? So from my point of view, in order to evaluate the effectiveness of the work of the investigators, this is not needed. But this is needed for the development of the staffing levels, of the staffing requirements, because at the moment, this actually completely undermines the work of the investigators. So regarding implementation of such a procedure as inquiry, which is envisaged by the CPC, and with regards to the criminal misdemeanor, we need to agree that at the moment the law enforcement bodies are engaged in the process. So on the one hand, we have got the concept which is being developed without consideration of the opinion of the law enforcement bodies. On the other hand, so the law enforcement bodies take their own approach without the discussion with the civil society, and this is one of the key problems from my point of view. So the absence of the contact between these two powerful aspects, so scientific and the practical one. So this is the basis of the conflict, and which has caused a 5-year delay with the implementation of these criminal misdemeanors. What should be a criminal misdemeanor? So this is one of the most important questions which should be solved. From the conceptual point of view, maybe it is worth to provide the list of crimes, offences, which should be investigated in the form of inquiry. The second option is to provide the criteria for the breaking down these crimes by the gravity, so and the type of punishment. So although this approach was criticized, as far as I know, this approach was selected within the draft law which is being developed by the Ministry of Internal Affairs, and the NPU, and I think it has got the right to be presented and considered. So, and we need to get the feedback from all stakeholders, but the main thing is that any project, any draft law should clearly define the investigation in the form of inquiry. However, the chapter which is devoted to the inquiry doesn't provide the scheme how the investigating officer will be acting in case of investigating in this form. Can specific procedural actions can be taken by the investigating officer before registering that in the Unified Register of Crimes? So in case if a person is detained, what actions should be taken? So taking evidence, recording evidence, so etc. So all these issues are not clearly defined in the CPC. So for those who will be undertaking these actions in practice will be critically important, and that's the primary issue which is of interest to them. So, and I hope that I managed to fit the time limits. So that's my views regarding the reduction of the workload. Thank you very much, Denise, for a comprehensive approach, and thanks for recollecting the fact that we need to consider the issues related to the courts, because they also experience significant workloads, and it has got a significant meaning for consideration of this problem. I would like to give the floor to Mustafa NAYEM, the MP of Ukraine, and he will provide information from the legislative point of view. So, and you have got 5 to 6 minutes.
First of all, thank you for inviting me here. I think a lot of things have already been said. Yes, speaking about the workload of investigators, the draft law which Mr. KHAVRONIUK took part in, and now it has been postponed, and the main reason it's not because of its contents, because in its essence, this draft law, what was proposed in this law, how to address this problem, I think it was good because the Ministry of Internal Affairs and the Prosecutor General's office had no objections, but perhaps there were some other objections related to inquiry. But those problems could be addressed and we could be dealt with for the sake of investigators. So because of this, I would like to go back to the systemic problem which we have, because I have a feeling, because many people have a lot of practical experience in this area. We have lawyers, prosecutors here. I, as a person who has become a lawmaker recently, I have a feeling that sometimes we don't understand why we are doing this, because oftentimes this becomes a war between various institutions. Activists are killing whatever the national police is doing. The national police, whenever sees any criticism, then excludes these people from the process. The General Prosecutor's Office believes that any intrusion in lawmaking should be excluded, and then we end up having draft laws which cannot be practically implemented, even though they are written beautifully. Sometimes these draft laws refer to decisions of the Council of Europe, of the Venice Commission, but when you ask the authors of this draft law, have you ever talked to people who have practical experience in this? It turns out that they didn't, because they think that if something is written abroad, we have to borrow it, and then it ends up in Parliament. It's brought before MPs for their consideration. And then in Parliament, only 10 or 20% of people understand a thing or two about this. And even those who understand, only half of them read the draft, but the rest of them just follow the crowd, and sometimes they don't know why they vote this or that way. But when a person who has practical experience comes and says this and that is a concern, but another person says, but in Europe it's this way, then the MPs will listen to those who say this is the European best practice. So perhaps we should make a step back and then start negotiate again. Now we have the same problems with the law on operative search activities, the same with the draft law on criminal misdemeanors. As far as I can understand, there is another draft law which was developed together with Mr. Strzeżewska, and General Prosecutor's Office has been agreed already. There are some legislative ways. There are some committees who are involved. We understand that this draft law has more chances to go through. But then the question is why this draft law was developed somewhere, but the MPs did not know about it. This kind of procedure, when whoever takes part in the development of a draft law, but not MPs, it seems to be a standard now. For example, we are now considering a draft law on the sovereignty of Donbass. MPs don't know anything about it, but then we will have to consider it within 2 days. Now, about this draft law on criminal misdemeanors, I hardly know anything about it. It's not because people don't want to share it with me. It's because it's still under consideration. People are discussing it. But then when this draft law ends up in the committee, those people who do not know anything about this draft law, they will be adverse to this law because they don't know anything about it. They think that some intrigues are underway, but the investigators who suffer every single day, no one asks for their opinion. And I think this situation is absurd. And the last thing I would like to say about the legislative branch. It's about the newly created, or a body which we want to create, is the State Bureau of Investigations. We have very great hopes. The public has great hopes. Politicians and MPs and international community have great hopes that we will have a body which will be able to concentrate all these functions and will finally start investigating other law enforcement agencies. We understand what kind of influence this body will have. We understand that this is a very important piece of power, and some people will want to get hold of it. And we saw the candidates, we see who is being pushed through, but it seems to me that we have to say these things to ourselves. This kind of body cannot be created in this atmosphere of mistrust. When Parliament does not trust the Cabinet of Ministers, the committees do not trust each other, the public does not trust anyone. There is already a case against one candidate. There is a case against the actions of a committee. Just imagine if tomorrow we choose the head of this bureau. Who will trust this person? Members of the committees, activists, experts, government, president's administration. Who will trust this body? Whereas this institution is supposed to have such a huge level of trust that the prosecutor's office would be able to transfer cases to this body. So trust is crucial. So now I think we need to come down and admit one thing. We have not been able to create a Bureau of Federal Investigations the way we wanted to. Whether it's good or bad, we can't create whatever. just because someone wants to head this institution. Now, okay, we haven't been able to create this bureau. Let's say two things. The law on SBI is not perfect. And people are talking about amendments which have to be made to this law, even though it's non-existent yet. The government consists of Poroshenko bloc and the National Front bloc, People's Front bloc. And there is no consensus because people have different opinions about how to proceed with the State Bureau of Investigations. Some people push it through and some people say, well, there is nothing to be done about it, but everything is being done to procrastinate. So anyone who is in the committees and anyone who is in the prosecutor's office, in the Ministry of the Interior, they should all make a decision, okay, let's relaunch this process. This would be good. The committee that we now have, and I am not talking about individuals, now there is lack of trust because two members of the commission do not have a law education degree. One is trying to get one, the other says, oh, that's okay. But the commission says, you know, all the decisions were adopted without these two candidates. Cool, isn't it? Okay, if it's a collegial body, no problem. But my point is that there is lack of trust. So that's my proposal, which I voiced to the Prosecutor General, to the Ministry of the Interior. We have to communicate it together, perhaps, so that we will not be destroying everything. We need to address the issue of discreditation of this body, but not pretend that there is no problem. Thanks.
Thank you very much for the suggestion to have a constructive discussion, and I think the participants of our event do share this approach. The main thing is to start it, and now I would like to give the floor to Mr. CHIBISOV, Chief Prosecutor of the Kyiv region. That will be the last presentation, the last speech, and then we'll start the discussion. So once again, I would like to welcome all of you, those whom I haven't seen. I would like to say that I'm a practical expert. I'm not a politician, and I'm a realist. So I'm a strategist and tactical specialist in this sphere. At the moment, we are discussing specific issues which obstruct the work of the system. Before that, I said that the law enforcement system can be compared to a machine, the vehicle which is working, but one wheel is not working properly, so the other wheel is not working at all. So all parts of this vehicle should be working at the same time, then it will be comfortable and we would be able to reach our destination. Unfortunately, as it has been said before, so in Kyiv region only there were 60,000 criminal proceedings, and you can imagine the workload on the investigators. So the crimes which were committed, so the majority of these crimes these are minor crimes, and therefore it's worth starting with the reduction of the workload for the investigators. At the moment, the investigators are able to investigate and use the same procedure for the standard theft and use the same procedure for the crimes with the engagement of organized criminals. So, for example, this year we were investigating the drug dealers who were using certain techniques for transporting drugs from different countries, and that was in Kyiv region. So, for example, 2 days ago, we were undertaking necessary actions with regards to these drug dealers. So recently, we solved the case regarding the group of persons who wanted to transport a former Russian citizen who is now a Ukrainian citizen. So because they have been promised 17 million. So lots of cases, but all that shows that an investigator has got the same procedure for investigating these different cases. So if the same procedure is being used for different cases, so if, for example, a person has been caught stealing, so he accepts that he has committed this crime, so the victim acknowledges and agrees to the cost of the property lost. So why do we have to have all these tests, experts, analyses, interrogations, and etc.? And then we have to send these cases to court. So let's simplify that. So let's use the simplified procedure. So the court will be making a lawful legal decision. So first of all, it will reduce the overall workload. Secondly, previously we discussed that there is a pilot project regarding the investigation of cases, and the investigator has got the same strategy as the operative or detective. So the jury, we don't have such a notion as detective, but according to this pilot experiment, so the investigator can become more operational and more effective, and this is the way how the investigation mechanism can be improved. So other mechanisms I would like to highlight: electronic proceeding systems, which we would like to develop, but this is just a single e-case mechanism which exists in many other countries. In European countries, such a system provides with an opportunity to improve the work. So, for example, in Kyiv region, so with the support of the Prosecutor General, we are starting this project, and then it will be possible to roll it out in other units. So the idea of this experiment is that we have got the unified pretrial investigations register. So although the system has got certain levels of protection and we have been using it for a number of years, it's not possible to accumulate the documents. In practice, it means that if an investigator in the rayon takes the case to the prosecutor, when it turns out that it wasn't investigated properly, instead of investigating it again in a proper way, so then they get a response from the prosecution. So then they bring up these materials to other levels of the prosecution bodies, and all these materials are being delivered to different bodies, and 70% of time which should be spent on the investigation of cases is essentially spent on the ineffective actions. And therefore, the concept which I propose and which has been proposed by the Prosecutor General is to make the e-document flow. So you scan the proceedings documents, so you with providing access to necessary bodies, and in order to control the investigation process, you don't need to bring the materials to different bodies. And if we look at this problem at the national scales, you can imagine what costs and what time we are talking about. So in the electronic system, you would be able to monitor what stage the proceeding is at, what regulations, what instructions were provided. So this can be established on the basis of the Unified Pretrial Investigations Register. This would provide us, so apart from the criminal proceedings, we have got some other documents, requests, motions, petitions. Again, we have to deliver them. So we are bringing them from one place to another. Why do we have to do all that? Why do we do that if we can send it in the electronic way? So, and we need to regulate it from the legal point of view, legislative point of view. So, but overall, it will eliminate corruption because there will be no prerequisites of bringing this document to bring these documents to court to understand the position of the court. So all these documents, for example, a petition is being sent to court, then and you get the answer if it is satisfied or not. This will increase the efficiency. It will increase and improve the time. So and the corruption risks will be reduced. So the analytical block, which is also part of this unified register, at the moment we don't have any databases. So if we open up a criminal proceedings, we start the tests from scratch. For example, the task of the prosecutor, when I have started working, so there used to be 45,000 of criminal proceedings. I didn't start from scratch in my activity, so and therefore I'm responsible for what happened before I started working. In terms of analytical work, you will have a chance to use the experience which was developed before. So we need to have a database where we can record all the evidences with the expert conclusions. So, for example, a certain thing was stolen. So there is analysis of the proceedings where similar things were stolen. So if we have got such a database for the analysis, it will also improve our work. At the moment, we are also missing a system of video surveillance and control. Also, in Kyiv region, we would like to implement a project which will give us a chance to use some modern technologies in order to support all the specialists of the law enforcement bodies so that they can counteract crimes and perpetrators. So the video surveillance systems provides us with opportunities to record not only the transport vehicles, but for example, we know that a crime has been committed in a particular area, and a person who has committed a crime, for example, we know he was dressed up in a yellow coat, so, and then I can set certain criteria to identify where persons wearing yellow coats are located right now. So then we can use a system, so the same system for the recognition of faces of perpetrators. If we have got the similar characteristics, if they coincide, then we can forward the police officers into these areas. So this will again increase the efficiency and improve the timing. Regarding the problems of the system, so there is a problem which we don't discuss, but it's not very relevant right now. So when we sort all things, then we can come back to this issue. So we still continue working in this work. So we have to work with the agents. So, and if we talk about the Soviet era and the best practices of that time and the European practices, and make a combination and develop a unique system here. So let's consider what we used to have in the past. We didn't have mobile phones, computers, IP addresses, so we didn't have traffic or whatever. So the operative worker came to the area. He knew that there was a criminal element, so he knew his informants, and he was able to get the information and resolve the crime. So, and there were no technical means to resolve the crime. So the informants are important, but we need to make necessary changes. That at the next stage, so when we make changes in the detectives institute, so the detectives should have the right to have informants. I would like to finish my presentation, not to take too much time, but I have got some other points which are important for the solution. So it's like a bottleneck. For example, if we look at the national scale, we have got a huge bottle, so, and a very narrow bottleneck. So, and we are only able to work in the area and the capacity of this bottleneck. And the drawbacks and the gaps which I see and which I have described are aimed at the extension of this bottleneck to increase the efficiency and capacity of the system. And of course, we need to have some legislative initiative, but the most important thing is to have the initiative on behalf of people. So we're working in all the directions, and I'm sure that the priority for me is the security, safety, and legality. Thank you very much. Thank you very much for the interesting discussion and the focus of your presentation, that the solution in the workload of the investigation lies not only in the legislative sphere, but also the technical area. That was a very interesting presentation, and I think everybody would agree that we have to use it not only in the prosecution bodies, but also in other law enforcement bodies. And now I would like the audience to take part in the discussion.
Today we heard a lot of interesting initiatives, ideas, meditations, and so on. At the same time, I would like to emphasize that there are a lot of incomprehensible terms were used. For example, I do not understand when the main investigator talks about criminal crimes. I don't understand this term because my name is Serhiy Petka, and I always criticize my students who use this criminal crime term. I'm a professor. Another term I don't understand, which was voiced, it's investigation of crimes in the protocol form of inquiry. I don't understand this term. And my question is, look, everything that is new is actually old things that was forgotten. Now we're talking about criminal misdemeanors, which are supposed to help reduce the workload of our investigators. So the prosecutor's office and the national police are trying to introduce this new institute that Kari LAMBERG talked about. He talked about chapter 25 of the CPC. This term, criminal misdemeanor, is mentioned, and his proposal was to replace it with a minor crime, which are mentioned in Article 12, paragraph 2 of the Criminal Code of Ukraine. So why do I believe that criminal misdemeanors are familiar to our public? What is a misdemeanor? For example, 5 grains of wheat which were stolen by a person in the field and was shot dead for doing this. Or when a person was moving in a convoy of cars, this person could be brought to justice for this. So my question is, why do we, using as a cover the idea of our experts, foreign experts, why are we trying to introduce some kind of institutes which they regard as absurd, illogical, and such that will only make the situation of our citizens worse? Thank you. Who could give a short answer, please? Dear colleagues, I see that this problem could be solved in a simple way. First of all, the head of investigation it was a slip of tongue on his part. Let us not criticize such slips of tongues that were mentioned at the beginning of your question. Look, the structure of offenses is simple. There are crimes as the most serious criminal offenses, and then there are criminal misdemeanors, which refer to the sphere of to the criminal sphere, but are still misdemeanors because they are not serious. And finally, we have administrative offenses, and among them we single out administrative misdemeanors. All offenses are offenses against the system of governance. So some of them are considered justice, and some of them are handled under protocols. What is the difference between administrative and criminal misdemeanors? Administrative misdemeanors are only about violating one administrative standard or norm. In industry, in agriculture, or in any other social sphere, there is no criminal element in this kind of offense. But in our criminal code of 1984, we had a problem when we ended up having small criminal misdemeanors. So now we need a new code provision about criminal misdemeanors, and we need to envisage fines for these criminal misdemeanors. That's it. And it would be processed under simplified procedure, especially if the person agrees with its guilt, recognizes all the evidence, so it just pays the fine and that's it. But for criminal misdemeanors, the system might be a bit more complicated. Perhaps the police will deal with it, but the proceedings will be more complicated because it has to be supervised by the prosecutor. And how we build this inquiry system for criminal misdemeanors, there are two ways we could do this. For example, in some countries, no investigative actions are taken, but the police officer makes a big protocol where he describes all the circumstances, and then, if needed, he comes to the court, and the court will interrogate the police officer if indeed he heard this and that from this or that person, if he has this tangible evidence, and if needed, based on his words, the court may interrogate those persons and then get evidence, because the protocol itself is not evidence. And there is a different system when a body of inquiry will make, just as an investigator, a protocol and then send it to court for further consideration as evidence.
So, I'm the head of the Department of Criminal Process of the Institute of Internal Affairs. So my first question was to Mr. CHIBISOV, but he has left. So my second question is to all experts, and today we have discussed the idea of merging of authorities and establishing a new position of a detective. So for me, as a person working in the education sphere, so for me, it's important from the point of view of reforming the education process, because at the moment in the higher education institutions of the Ministry of Internal Affairs, so there are different departments, different faculties based on their specialization. So what will be the changes? So, and what about the retraining of the existing police officers? Is our system ready for that? Unfortunately, we don't have the necessary representatives. I think the moderator knows the best answer to that. So, but I'm ready to hear the opinion of Mr. NAYEM. Thank you very much. So I haven't been in the system of the Ministry of Internal Affairs for a long time, but I think not all the police officers acknowledge that, but let's do that together. The Institute of the Academy of Internal Affairs that we have got at the moment is not compliant with the modern requirements. We understand that it's a monster which has got a high level of influence and is the place where the old values are being kept, and that's the biggest problem why any manager of the NPU or the Ministry of Internal Affairs is not able to do anything against this structure, because all these people have got big opposition to that, because all of them have got people who would like to study there, are studying there, or have got some personal connections there. And I think the education system and the curriculum for the police officers is aimed at keeping these education establishments and is not aimed at training of the specialists, as far as I know, with regards to what is being developed by the head of the NPU. So there is an idea to have a pilot experiment or pilot project. So as if we agree that we are not able to do or change the past and the current system, but in any country, there are no countries with the academies of the internal affairs, but there are, in other countries, there are police academies or academies for a particular specialization. So if they would like to follow this system, they can work in the system of education in general, but also this problem is related to the fact that a person who hasn't been able to, or hasn't had any experience of working on the street, so in the areas, in the district, so, and these people therefore are not able to understand what is being and how to work in different areas and at different levels. So if this person doesn't know the work of the police at different levels, so this person is not able to manage. There is now an idea to have a pilot project, so, and with a particular district, so all the staff members will be appointed from the patrol officers. So at the moment in the patrol police, we have got representatives of different police bodies. So these people will be trained, so will get specialization. So as we have said, they need to have to use the experience of the past. In the Soviet times, there was the mentorship practice. So let's take our patrol police officers, so train them to be investigators. Then we send him back. So then we assign a mentor to him. So he passes the exam and starts working as an investigator. So, and in this case, this person will know how the work is organized. He is not going to have any personal connections, and this person, if interested in further career development, so this person will be developing through these short training courses. And if we have this pilot approach in one district, and if we have got a small model of the police academy, so we can develop and train people for particular positions within the police. In the internal affairs, in the National Police of Ukraine, so there will be no people who would acknowledge the need to have the reformation of this system. Thank you very much. Unfortunately, the time is running out, and I would like to thank our speakers, and I would like to say that the issue of the high workload. So one more question, please.
Oleksandr Kari, head of the unit of detectives of NABU. Today we talked about how to optimize the workload of investigators. But we forgot about one important issue. That is prevention of crime. So not just investigating what has been committed, but preventing crime, which would help decrease the workload. So I think we need to address this issue and consider how to reintroduce this institution of prevention of crime to the Criminal Procedure Code. Unfortunately, now it is absent. It used to be in Article 23 prim, but not anymore. I will give a practical example to emphasize the importance of this norm. For example, when we conducted an investigation against the Desa port side plant, we conducted an investigation, but then the decision of the court did not assign to fire the heads of this senior management of this plant. And after we raised this issue at the state level, we know that these issues are being solved and some administrative measures are being taken so that to make sure that these people resign. Also, the plant used some schemes to buy goods and sell them at buying goods at very low prices and selling at very high prices, and then making profits on this difference. So we are filing motions to address this issue, and we do have some results in dealing with these corrupt schemes to make sure that this enterprise will not be able to conclude contracts anymore and so on. I think this issue had to be addressed more attention. Prevention of crime by means of operative activities. Because we talked about operative activities and covert investigative activities as synonyms, but in fact this is not the case. Because operative activities involve informants. It's quite different, it's much wider. If we look at Romania, for example, they have in-house and undercover officers who work in educational institutions, for example. They help prevent crimes. They get special tasks. Article 272 of the CPC is also used by our agency. Why am I saying all this? My point is that it is easier to prevent crime while it is being prepared rather than investigate when it is already committed. For example, perhaps you heard about conversion centers. We analyzed 2 weeks of operation of such a center. 5 investigators investigated this for 5 years. So perhaps it's better to talk about prevention of crime, to nip it in the bud, rather than investigate when it is already there. So this should be taken into account. And thank you.
So prevention was mentioned by also the representatives of the prosecution. So I'm a representative of the Prosecutor's General Office. I have got the question to you, Mr. Khavroniuk. So regarding the changes to the CPC and introduction of the misdemeanors notion. So I know your draft law, so it has got around 200 pages. So it introduces conceptually new approaches to criminal liability, responsibility, and therefore my question is it reasonable, bearing in mind that 70% of changes, so that this law will introduce 70% of changes to the codes. So is it necessary? Is it better to adopt a new code? So if we introduce the misdemeanors, will we lose certain categorization value of other crimes, and therefore classification of crimes will be made more complicated? So these 2 questions, please. There are different approaches with regards to the categorization of criminal misdemeanors, and they can be established a separate code. and we developed such a code for Kyrgyzstan, and it was already adopted. So, and very soon it will come into effect. So criminal misdemeanors can be included into the CC itself, and they can be categorized by certain criteria, sanctions, for example, and there can be an option that we are proposing. The reason why we have chosen this approach is to avoid duplication or having the general part twice. So because it is very, very similar, and having two similar laws is unreasonable. As for the first question that you have asked, whether it is reasonable to develop a new criminal code, so maybe it is reasonable, but it would be good to follow a certain tradition. And I remember that in Germany, until today, so the code which was introduced in 1871 is still in effect. So they do introduce certain amendments, they make necessary reforms, and maybe over the last 10 years they have made several changes, but not several hundreds changes or amendments as we do. We need to accumulate a certain amount of changes and amendments and process them in one go. So then we won't have such problems, especially those which are related to the effectiveness period of the code. So for example, like the law of Savchenko as a recent example. So however, the issue and the proposal whether there is a need to have the new criminal code is being raised by different representatives. So recently this issue was raised in Lviv by Navrotsky. So I'm helping them in this direction, but this will take 10 years. Thank you very much for all those who presented and asked questions. So, and I hope that our discussion will generate a dialogue and cooperation in this complex issue. Now I would like to announce the coffee break.